Hello, my name is Dr. Brett Davies. I'm a barrister and solicitor at Legal Consolidated, and I specialise in taxation, superannuation and estate planning. And that's the topic for today, because you have 8 wills that are available on our law firm's website for you to build. Let's go through all 8 of them. The first one, let's take the single will. So a single will is for someone that's husband is dead, wife is divorced, but there's just one of you, you're by yourself. And what you're doing there is you are going to, in the first will with no choice, the first single will with no choice, you're going to leave everything to your beneficiaries equally and make them your executors. Well, who would use that? Well, quite often a single parent that has adult children where you're leaving everything to the adult children equally. So they've reached the age of majority, they're of age. Let's say you make the age of majority 21, they're all over 21, and when you die, you make them all the executors. You might have 8 children, all 8 are made the executors, and all 8 share equally in the estate. That's 1/8 each. It's done automatically for you. If you like that, that's your single will with no choice. Now the next will is a single will with lots of choices. And this is again for a single person, so your husband is dead, or you're a single parent, or you're just never got married. And you can name all your executors of different ages, they don't even have to be beneficiaries of the estate. You can then put specific gifts in there. I don't like specific gifts, but you can put them in there, like your E-type Jaguar or something. You then put your residuary beneficiaries in. You might put in 8 of them. One person gets 12%, next person gets 16%. As long as it all adds up to 100%, like a third, as long as it all ends up to be 100%, you can use that, the single will with choices. It also deals with other situations where your children are under 18 and you want to put a guardianship clause in. Someone might challenge your will, you might be getting divorced. Divorce revokes the will unless you mention it in the will, and this does it for you. A marriage, if you get married after you make your will, that also revokes your will, so we cover that situation as well. So the first single will, no choices, everything to the children equally, and they're your executors. Second single will, lots of different choices. Okay, that's for single people. There are now 2 wills for a mum and dad or a couple. Maybe they're de facto, maybe they're married, maybe they're gay relationship, but it's a 2 people with significant other test. So my partner's my significant other. Well, in a mutual will, they're leaving everything to each other in the first instance. Dad leaves everything to mum, and mum leaves everything to dad. They make each other the executors. That's the first part of the will. Now, after they die, and the questions then only relate to once both of them are dead, either in a car accident together or 20 years apart. The first mutual will is no choices. Everything goes to your children equally after mum and dad die, and your children are all the executors. Mum dies, everything goes to dad, then dad dies, everything goes to the children. Let's say there's 4 children, everything goes equally to those 4 children. The 4 children are the executors. Well, who would do that? Generally old married couples that have children that are all adults. That will would suit you. Now the third type of will is the mutual power of attorney with mutual will with lots of choices. So again, dad leaves everything to mum and mum leaves everything to dad in the first instance. Once they're both dead, either in a car accident together or 20 years apart, then the rest of the estate is dealt with, and they're mutual wills, so they're identical, they're mirror wills. So you'll put your executors in, might be your children, maybe your children are underage. You may still appoint them provided they're 18. It might be you might appoint some uncles or aunties. And then you come to the residuary beneficiaries. You can put lots of different people in at different percentage rates. You have specific gifts, deals with marriage, whether you're going to get divorced, all those issues. So who would do that? A married couple with young children or with disabled children would probably want to pick that third type of will, that mutual will. So that's your 4 wills. Now, those 4 wills are repeated again. So there's 4 wills and another 4 wills that are identical, except the second lot of wills have tax effective estate planning in them. Now, any of those 4 wills with no tax planning, or you can have tax planning. So what's that mean? Well, death and divorce are 2 great times to tax plan, very sad times, and when people get divorced, they just want to kill each other. They don't really have much interest in helping each other, which is unfortunate. When you die, you can get massive tax advantages as well. So now's the time to tax plan. So what can you put in the tax effective will? Whether it be a single will with no choices, a single will with choices, a mutual will, dad and mum, with no choices, or a mutual will, a mirror will with lots of choices. Each of those 4 documents can be built with full tax effective status, such as 3-generation testamentary trusts, so that each child can have their own testamentary trust, saving lots and lots of tax. You can have a superannuation testamentary trust. These are all put into your will. So if you have superannuation and the assets go to non-dependents and the tax rate's 32%, quite often your tax rate will be 15% plus Medicare or 30% plus Medicare. The superannuation testamentary trust will attempt to wash out that 32% tax. There'll be bankruptcy clauses in there, bankruptcy trusts in case one of your children or beneficiaries are bankrupt at the time of your death. There's also considered person clauses where they're dealt with in a very tax effective way. Maintenance clauses at the highest level, so that if a person's bankrupt or underage, even if they're under 99 years of age, it will deal with all those situations. So you've got 8 wills. 4 of them are not tax effective, are straightforward, simple wills. The other 4 are tax effective wills. Now you can start building any of your wills. There's lots of hints, lots of training videos, and also there's an additional advantage which you've got because you've come to a law firm's website. And that means that you get retention of legal professional privilege. You get legal advice. You can even telephone us and we can help you answer the questions because we are a law firm, we're lawyers. You get our law firm's professional indemnity insurance. You also get a law firm's letter with the will to help guide you on how to sign it and all other issues that need to be dealt with. So enjoy the advantages of dealing directly with a law firm because only a law firm can provide those services.